Well, good evening, everyone. My name is Max Domar, and I'm a member of the law school here at Queen Mary, University of London. So welcome to Queen Mary if it's the first time that you're here. It's a delight for me, although it is one tinged with a bit of melancholy, as some of you will know, to welcome you to tonight's lecture, because it is the 10th, but also the final Cotterrell lecture in sociological jurisprudence. I can't think of a better person to end the series with than our guest tonight, Professor Wendy Brown. But just before, it really is a dream for us that you're here, so thank you for being here. And I'm going to say just something very briefly to introduce her in a moment, but I hope I can be forgiven just to say a few words, given it is our 10th and final lecture, just as a reflection on the last 10 years. And the first and most important thing to say is to say a really warm thank you to the person who lent his name reluctantly. We've had a lot of convincing to do. Reluctantly lent his name to this lecture series, and that's Roger Cotterrell and his wife Anne, who are with us and who have been here with us for every lecture. And I wonder if you would join me in showing our appreciation. So one of the ways I was able to convince Roger to lend his name is to say that this was to be a collective exploration of sociological jurisprudence about what it has been. Also here at Queen Mary, we have a long tradition of interest in sociological jurisprudence, but also what it is like in other places and times, what it has been, what it might be. And we've been doing that over the last 10 years, really across many, many different disciplines. So we've had historians, anthropologists, political scientists, philosophers. We've had English and drama professors. We've had really a wide range, of course some lawyers, a really wide range of disciplines coming together. And I thought I would just actually say the names of those who have given the lectures before, just to give you a sense of who, and in case you've not been to some of them before, and the breadth of the guests we've had. Brian Tamanaha, that was in 2015, Eve Darian Smith, Kwame Anthony Appiah, Annalise Riles, Scott Veach, Renisa Mawani, Lorraine Daston, Julie Stone-Peters, Rahel Yaegi, and this year, of course, Wendy Brown. And you may, if you've been to the other lectures, already have a sense of the kind of themes that kept recurring over the last 10 years, but I thought I would just mention, from my sense, what those sort of three themes that seem to be overlapping. Many of them have been around community, democracy, and identity, which I think are also interests of our speaker tonight, around citizenship, belonging, migration, post-nationalism, transnationalism. We've had a whole group around the themes of knowledge and media, going from very familiar technologies, at least in the law school, like rules, through to cameras, models, exemplars, casuistry, digital platforms, surveillance, performance. And we've then had also a theme around norms, normativity, and justice, more familiar, I suppose, in many ways to lawyers, around obligation, rights, social justice, progress, regress. There have been sort of the themes that have, I think, and also some of the language and terminology that has kept recurring over the last 10 years. I should just say that all of the lectures are available and recorded online. In case you missed some of them, you can go back, and it's a little repository of sociological jurisprudence, a snapshot of we like to think of what it might be over the last 10 years. So you've not come to hear me speak, obviously, so I'm going to be very, in a way, sort of embarrassingly brief in introducing a speaker tonight whose work I'm sure is familiar to all or almost all of you. We have, Wendy, in the audience some jurisprudence students graduate jurisprudence as well, students who, for their benefit in particular, let me say that Professor Brown is the UPS Foundation Professor in the School of Social Science at the Institute of Advanced Studies at Princeton. Before that, she was for many years at the University of California in Berkeley, where she's Professor Emerita now, and has worked at a number of institutions before then. If I had to put it in a sentence, I would say that she's one of our great defenders of the very idea of the political, or of politics and its value, including the practices that make it up, that are important to it, to sustaining it, judgment, deliberation, pedagogy, the languages and imaginaries that endanger it, and the associated technologies, such as those with the figure of the Homo economicus, and the values at stake, in particular perhaps democracy, but also numerous others, as well as being a wonderful explorer, I think, a wonderful reader of the heritage of thought about politics. I've been really enjoying recently her work on Max Weber. And for us here at the university, Wendy, it's particularly, I think, poignant that you come at this time where your work on the value of education for democracy couldn't be more relevant and important for us as we think about the future of our university. So it's especially meaningful and important for us that you're here. So thank you very much, and can I invite you to give up?
Thank you, Max, for that introduction. It's really an honor to be part of this series, and I add my thanks to Roger and Anne for making it happen, and I'm sorry that it's coming to an end. May there be something that arises in its place. That, I think, is what we say a lot these days. This has been an unusually difficult lecture to prepare. Last fall, when I gave Max the title, I thought I would simply use the occasion to develop the law and politics section of a project I've been at work on for a couple of years on reparative democracy. I'm going to say a little bit about reparative democracy, and then I'll tell you what got so difficult about writing this lecture. So, reparative democracy. It's not aimed at restoring liberal democracy to its mythical former splendor. It's not concerned with moral reparation of past wrongs, nor is it, for me, a normative concept. Rather, I am developing the idea, the practice, with an understanding that it is already a nascent successor form of democracy, one that's oriented by the enduring damages to both human and non-human life that have been accrued from capitalism, colonialism, and liberalism powered by fossil fuels, and spurred by the crises now erupting at the site of these damages. As reparative democracy takes shape amidst these damages and crises, just remembered I have a PowerPoint. Got lost to the introduction. As it takes shape amidst these damages and crises, the past they indict, the future they condition, reparative democracy breaks with liberal, social, and even radical democratic temporalities, that is, modes of relating past to future, ontologies, ways of figuring and relating, human and non-human, and spatialities, understandings of where democracy resides and matters. Reparative democracy departs other forms by replacing modernist binaries, human versus non-human, past, future, individual and common, culture and nature, political and economic, with imbrication and connection. In place of the trope, humans and their environment, reparative democrats live on a delicate, damaged planet with other species by which we are either sustained and sustaining, imperiled, or imperiling. No life thrives or regenerates apart from the common, and the idea of culture apart from nature, let alone culture mastering nature, now appears as a terrible joke. Above all, reparative democracy responds to the problem that we will never be free of the political and ecological residuals of what Andreas Volkers terms fossil modernity. Residuals that are themselves agentic in the making of planetary futures. This is as true of the politics of the post-colony as of rivers fouled with cadmium, selenium, and arsenic from mountaintop mining runoff, climate change, or plant and animal microbes learning to metabolize plastic. We will end fossil fuel use, or it will end us, but the immense and enduring social, political, economic, and ecological residuals of fossil modernity shape every aspect of every possible future now. Such is the unique history that the Anthropocene set in motion, and why we still need the term, whatever its limitations. But reparative democracy is not only a project of reform or retreat of modernist aspirations and utopias. Rather, it aims at remaking democracy's golden promise, that we rule ourselves together in order not to be ruled by one or a part, the rich, the wise, the dynastic, the expert, or by impersonal forces, markets, money, technology, church, bureaucracy. That we are political equals in this common rule, sharing power and politically free only to the extent that we engage in such rule. This much is familiar from older traditions of radical and even republican democracy. The we of reparative democracy, however, is novel and challenging. It features the imbrication of non-human and human life. Its venues are less and more than national. Its institutions and practices not always state-oriented while not ignoring the state. Its temporalities, as I suggested, are also novel. In contrast with liberal democracy's presentist and interest-heavy orientation, reparative democracy is oriented by a reparative relation to ecological and social damages of the past that could produce livable futures. It thus entwines rather than separates planetary and human histories and the futures they shape. It's a form emerging from the ground in countless places: the Amazon region, Standing Rock, Tahrir Square, Istanbul, Atlanta, universities in India, the UK, and the US, in struggles against deforestation and mountaintop mining, against ongoing deracinations of people and other species everywhere. In other words, I did not invent this newborn struggling for life. I'm only aiming to theorize it, identify some of its tensions, vulnerabilities, and dangers, along with its potentials. It is, I think, the other alternative to the nightmare of what we are seeing emerge from the crises we face today. In the portion of the work I thought to offer here, I plan to focus on how reparative democracy might overcome extant ways of incorporating non-human life into democratic practices and decisions, and into the we of democracy's constituency and purposes. I especially wanted to consider the limits of the constitutionalizing nature and rights for nature approaches, which, while utterly well-intended, have tended to humanize nature. Stranding by individuating it as humans are also stranded by the liberal individuation and formalism of rights, and leaving nature as largely unprotected against capital as humans are. This much is familiar from many critical legal scholars, some of the best of whom happen to be in this room. But the rights for nature approach also elides the transformations in both the demos and the kratia demanded by the Anthropocene, and especially the climate emergency. To achieve these transformations, rather than extend a problematic figure of the human to the non-human, in the form of rights. The human must be discursively and materially enfolded back into the earthly life from which it has been estranged across Western civilization, and especially its modernity. Even as it is being decentered and enfolded, however, our species also must attempt to remediate the immense damage our historical estrangement has done. Humans alone created the powers, forms, and practices that have brought planetary life to the brink, and humans alone can fashion alternative ones. If we now understand that we must inhabit the planet differently than we have, with rather than atop, regenerating rather than exploiting and extracting, imbricated rather than individuated, of nature rather than apart from it, this still entails becoming collectively more powerful, intentional, willful, and far-seeing as a species than ever before. What does it mean to attempt to intensify these conventional signatures of humanism? Power, will, intention, far-seeingness, while also trying to deconstruct the destructive humanism of modernity. This is one paradox of our predicament today. To become a responsible, remediating species, one alert to the historical residuals that necessarily craft our makings of futures. And to live differently in as part of nature is not to become less human, but differently so. This becoming different, of course, is not itself an act of pure consciousness or will. We're too materialist and too Foucauldian for that. But a matter of the subject constituting effects of politics, political economy, social relations. So we're also in Rousseau's paradox. We need to build the political culture that builds reparative democrats so they can build reparative democracy. Just a bit more on this fledgling creature, reparative democracy. I've suggested that in contrast to liberal, social, or socialist democracy, reparative democracy tethers the demos to the non-human and to histories of damage bearing on present and future. But both of these tethers alter, uncomfortably for many, the meanings and the temporalities of justice, which in the Western tradition have always tended to be timeless and immediate, eternal yet presentist, focused on outcomes now. This focus is at odds with responsiveness to agentic elements of the past and the present and future, to the radical interdependency of life forms, and to future thriving for multiple species. In reparative democracy, the immediate needs and demands of the present cannot dictate the terms of justice, and individuals cannot be broken apart from what sustains us. This cannot displaces justice centered on rights and distribution, with justice centered on thriving and regeneration amidst interdependence. Rights and distributions don't vanish, but thriving, regeneration, and interdependence govern. Reparative democracy also alters valences and practices of freedom, personal and political, to mobilize human capacities for democratic, ecological, and social repair. Freedom takes shape as relational, responsive, responsible. If neither individual nor political freedom lose their foundation in our singular species capacities to organize powers for chosen ends, this still could not be further from license limited by the human harm principle. Reparative democracy also entails a new iteration of robust political equality. Of course, it must be alert to deep histories of inequalities, supremacies, exclusions, both human and non-human, that shape discursive norms and agendas in democratic spheres. But there's also this. In reparative democracy, the voiced and the unvoiced cannot count differentially. This cannot supplement speech with listening as a democratic practice, exceeds measure by individual units, and does not correspond precisely to representation. Democracy remains a distinctly human practice, but this now means being entwined with our non-human others. How does this work? How do we tacitly, if not explicitly, enfranchise life forms that democracy has not previously bothered with, yet sustain all life? Earthworms, coral reefs, bee colonies, rainforests. What kind of equality and freedom affirms that their fate is in human hands, yet our fate rests with them? This is what I expected to consider with you today. So what happened? I will still visit some of this work because I promised it, and it hasn't become politically irrelevant. But the first 2 months of the Trump presidency in the US forced a swerve in my thinking. Trump's win, of course, surprised few political realists. What has taken all of us by surprise is the rapid, effective rollout of chaotic authoritarian governance facilitated by a detailed planning document, Project 2025, Pluto-technocratic sycophants, a docile Republican Party, a hapless Democratic one, a radical right Supreme Court majority, limp mainstream media, highly siloed social media, and a diseducated popular base. As Melinda Cooper has recently argued, and the Project 2025 documents make clear, one of the main purposes or projects of this regime is, to quote Cooper, build the antisocial state and place its entire administrative apparatus in the hands of a small group of uber-wealthy business partners. This governance form, however, did not come out of nowhere. Rather, it's the top blown off what has been building for decades, not only on the right and not only from neoliberal rationality, namely the exhausted or historically outmoded character of liberal democracy. The means of the new regime, bold power politics, detached from the restraints of law, balance of powers, concern with conflicts of interest, and more, revealed to us all how easy liberal democracy is to end run now. What do I mean by outmoded? Let's see where I am. Nope. More than merely the object of direct and angry assaults by the right, more than merely suffering the erosions and corrosions of neoliberalism, liberal democracy is inapt to the global nature and complexity of the powers generating our most serious predicaments today, from climate change to the predations of finance. It's also part of what has brought us to our current pass, carrying as it does empire in its belly, capitalism on its back, private interests in its heart, and fueled from the beginning by burning fossil fuels whose residuals do not, as Volckers notes in a jibe at Marx, melt into the air, but hang in it forever, as nanoplastics are now suspended in every body of water on Earth. Liberal democracy's laboriously slow and insedimented institutional ways are maddening to climate change activists, tech bros, and financiers alike. Meanwhile, capital, the radically undemocratic and democratizing force with which liberal democracy has been twinned since birth, has never been more powerful, more wily, more deeply entwined with state projects on the one hand, and on the other more global, less submissive to the nation states that housed modern democracy. Unable to reckon with its own violences and exclusions, human and non-human, and ever more openly manifesting its protections of elites, liberal democracies now hemorrhage populism, both left and right. Populism. The basic definition is popular rebellion against elite rule. It's an organic retort to undemocratic regimes masquerading as democratic. Indeed, one way to understand the right's success today is that it is far more willing to abandon this exhausted form than the left is. The right's objects of desire, ethno-nationalism, heteronormative families, unfettered wealth accumulation, police power, these may be backward-looking, but its aspirational political form is not. failure to grasp this blinds the left to where the crisis-responsive revolutionary impulses are today. Of course, the Euro-Atlantic world has for decades been departing the post-war vision of nations governed by rule of law, popular consent, advancement of human rights, and human welfare. Obviously, this was a vision that was never extended from core to periphery, to sites of imperial looting or Cold War struggle, or to the disenfranchised and subordinated inside the West. All of its terms, from rule of law to human rights, have their violences, their seamy undersides, their hypocrisies. Yet, born as it was, in response to the ugly regimes and aggressive power politics in Europe in the first half of the 20th century, the vision guided the building of Western social democracies and relatively peaceful cooperation among them. It was torpedoed first by the neoliberal revolutions closing out the last century as markets and finance were unleashed to savage everything, including the social state, and legislative intervention was spurned as social engineering at best, totalitarianism at worst. On the back of this anti-democratic force, power politics returned with a vengeance, an element of the neoliberal revolution predicted neither by the neoliberals themselves nor their Marxist critics. Notwithstanding the evidence of actually existing neoliberalism and state communism, both Marxists and neoliberals imagined economics could and would ultimately subdue politics, perversely mirroring each other in treating economics as real, politics as derivative. Neither appreciated that both distinctly human forms of power would endure and perdure, whether entwined or in tension. Nor could they predict that a form of governing reason, featuring deregulated economic life, would eventually deregulate political life as well, unleashing it from its legal and institutional containers. Trumpian power politics, of course, is importantly paired with economic bargaining, blackmail, extortion, and with commandeering the national treasury as its purse for this work and the Department of Justice as its personal lawyers for it. Combined with brute intimidation of disloyalists, the operation in some ways resembles the style of the mafia on which Trump cut his teeth as a New York real estate developer, yet with so many tools of state at hand. The Office of Management and Budget, Homeland Security, the Justice Department, and so many assets from the public treasury to public lands, and a supermajority in the land's highest court, this governance form does not depend on raw violence as a tool of last resort, even as that violence is on display and part of the rhetoric. Instead, its main tactic, from Ukraine to Doge to attacks on universities, replaces rule with dictate backed by the threat of economic ruin. This extra legal political power is slicing through the Constitution, legislation, regulation, settled procedures, organizations, agencies, departments, and liberal democratic norms ranging from balance of powers to the peaceful transfer of power to align with other liberal democracies. It is everywhere exhibiting what it can do to and with all of these things, not to mention what it can do to and with democracy and even capital at times, yanking, overrunning, or redeploying them for its own purposes. It is revealing how raw political will, yoked to economic largesse, can remake the state and potentially the world for minor and major ends. Supervenient political power, of course, has never borne the autonomy from law and economics that liberalism frequently imputes to it. Locke's notion of prerogative power is a reminder that liberalism always harbored a significant cache of state power apart from the so-called pillars of democracy in the legislative, juridical, and executive branches. Still, the intensity today of this supervenient and crudeness today of this supervenient political power, the Miele chainsaw, turned out to be such a rich icon. are a wake-up call to a left still bound almost exclusively to the social, to labor, to social movements, to street protests. And of course, they're a wake-up call to centrists committed to the imagined guardrails of putatively neutral institutions, procedures, and rule of law. Their presumed fair and enduring quality, their presumed non-manipulability, and non-suspension by political power. We might call this form neo-Schmittian on the right, for whom diktat is acceptable, and the friend-enemy opposition is defining. We might call it technocracy for the center, where metrics and algorithms replace bureaucracies and legislation as sources of policy and enforcement. My question, the question that interrupted the lecture I was trying to write for you, is whether such power could also be an element of what we might call a radical Rousseauianism for the left, those of us who wish to rival those other partisan aims with left democratic ones. Might our challenge be to develop what Anne Norton in Wild Democracy calls the necessity of a free people ruling the law rather than being ruled by it? This would require being open to strong democratic decisionism, to a new kind of statism, and to modes of consolidating decentralized popular power in order to organize it strategically for political fights we want to win, not merely protest. This is what the Trumpian revolution is forcing me to think about. Which brings us back to the talk I was going to give. Its focus was going to be forms of enfranchisement and representation, including voice and ways of incorporating the unvoiced, the non-human, in reparative democratic practices. The question, which I'll actually get to in a moment, was whether there might be ways of bringing non-human life into that most human of political forms, democracy, the one where the people rule themselves and much else besides. This question isn't trivial or unimportant, even in turbulent or emergency times like these. But what has transformed that question for me in recent months is whether and how the emergent political form I've been calling reparative democracy could rival the other one rising from the ashes of liberal democracy. Could my reparative Democrats do with power what the right is doing, in pursuit of earthly regenesis and justice, while exercising political freedom and securing political equality in ways that recognize and practice imbricated non-human and human life? Or are we too wary of the dangers of direct, deinstitutionalized political power, even in a democratic form? Are we too appalled by power as such, perhaps even too attached to losing to try? So in the time that remains, here's what I'm going to do. I am actually going to reprise the problem with rights of nature for the project of enfranchising nature in democracy. And then I'm going to very briefly turn to Bruno Latour's Parliament of Things as an alternative to that project. And then I'm going to bring these concerns together with the power politics problem. So, how to incorporate non-human life into democracy, not as a policy matter, but as an ecological democratic one. How to transform the demos, the people, the democratic subject or citizen, in such a way as to place our imbrication with the non-human at the very heart of our understanding of what it is to be human. How to build into democracy the non-negotiable imperative of fostering conditions of thriving and regeneration for all of the Earth's interdependent species. Rights for nature has been one answer to that question. A legal practice, a movement, and a strategy, it calls both enthusiasm and critique among ecological activists and scholars. The enthusiasm is easy to summarize. Rights are a legal device that confer recognition of their subjects as entitled to protection against violations that the right articulates. To bring nature into the purview of rights is thus a radical act of recognizing non-human life as deserving of legal protection. The code of the rights of nature movement, quote, ecosystems and species have inherent rights to exist, thrive, and regenerate, end quote. Concretely, rights of nature aim to provide modest security against spoilage, devastation, or worse, extinction. Ontologically, perhaps even cosmologically, rights of nature promise to alter, if not deconstruct, the person-thing, subject-object binaries of Euro-Atlantic modernity, and the property and profit-centered pillaging of lands, waters, and species wrought by those binaries. If Hannah Arendt's infamous "Who has the right to have rights?" highlighted the unprotected condition and moral political abjection of stateless peoples, rights for nature activists seek to do exactly this for non-human life. Okay, so that's the promise. The critique requires more time. There are philosophical, political, and practical concerns with individuation, temporality, representation, and figurations. Of course, the biggest question is, do rights for nature work? But let's start with the philosophical. Here I'm reprising what, again, many in this room have worked on in greater depth than I will give as treatment today. John Locke, the first major theorist of modern rights, distinguished between persons and humans. Persons, he argued, are conscious of past actions, while mere humans, along with things, do not have this consciousness. For Locke, only persons are the subject of modern rights, which inaugurated a legal fiction of personhood and its historical exclusions in the law. The 1948 UN Declaration would go on to declare every human entitled to personhood, hence rights. But this is an equation that theorists from Arendt to Agamben to Rancière would trouble, as on the one hand, the human disappeared into humanity, migrated into humanitarian discourse, and thence to humanitarian military intervention, and on the other hand, became detached from political belonging. Human rights also broke apart from democracy, the right of the citizen, at their post-war inception. These fates will meet the rights of nature as well. In his argument with Locke, Leibniz moved to identify the subject with the person. Kant took another turn, identifying the active principle of the subject as subjectivity and the capacity for moral reasoning. That subject's dominion, nature, and the broader world of things is for Kant neither subjective nor moral. Things are actors whose actions cannot be imputed to them. Thus, the political, moral, legal figure of nature in modernity is derived from the modernist figure of persons and constituted as its opposite. Persons are moral agents alone are entitled to rights. Nature is outside of this. So what happens when nature is afforded the rights of persons? Is the figure of personhood, constituting the subject of rights, altered? Are humans reintegrated into the natural world, cast by modern thought and practice as our non-kindred other? Or does nature get legally and politically anthropomorphized? As rights-bearing rivers get names and pronouns, nature is figured as mother or goddess, pets get health insurance and cemetery plots, dolphins and rhinos get tagged, numbered, and adopted. Is the figure of the human extended to more and more of the non-human world, undergirding a kind of legal philosophical greenwashing? Critical ecological thinkers, again, many in this room, have struggled with this. Could rights conferred on nature actually transform the legal fiction of personhood, to which rights have been historically bound, overcome the person-thing and subject-object opposition, undergirding the Western dualism between humans and nature? Or does it extend these dualisms as it grants rights to some parts of complex aggregates or ecosystems, but not others, thus conquering nature with the human yet again, confirming what Alexis Alvarez Nakagawa bluntly calls our narcissism. He invokes Heidegger's man everywhere and always only encounters himself for non-human rights that reinforce hierarchies based on human traits, rationality, agency, will, and feeling. This is Alexis. Humanity ends up being always on top, being the norm, model, and measure of non-human beings, by the same token that non-human rights give non-humans a new moral status. They take it away by surreptitiously establishing a hierarchical ladder which places humanity as its apex. While it's not trivial to say that non-humans are subjects of rights, doing so in the current conditions merely implies moving them from one end to the other of the legal binary. Far from displacing anthropocentrism from the law, Alvarez Nakagawa argues, it is its ultimate realization. Alain Potage uses exactly this frame to analyze Ecuador's 2008 to constitutionalize nature, to erase this distinction between human and non-human life in eligibility for rights. Built, Potage argues, on a Euro-American account of nature and consecrated with an intensive cluster of environmental organizations, law firms, and nonprofits, constituting a new juridical authority. This constitutionalization of nature, he argues, is not learning from nature, but from rights, and remakes nature in the image of persons who can then dismember, instrumentalize, and devitalize nature. This, of course, is exactly the sad conclusion of the 2008 constitutionalizing nature move in Ecuador. Immediately after the adoption of the 2008 Constitution, oil and gas extraction, ecologically disastrous palm oil and shrimp farming all proceeded apace. By 2009, open pit mines that had been halted by 2 decades of protests were restarted, and now the protesters against it charged with terrorism. The plan to strand 850 billion gallons of oil in the Yasuni National Park, one of the most biodiverse regions in the world, was abandoned. Those very reserves began to be auctioned off in 2013, constitutionalizing nature boomeranged into its opposite, as human rights have too often boomeranged into imperial military intervention. The political limitations of the Rights of Nature project emanate in part from the conception of personhood at their core. They pertain first to the individuation that this distinction confers on both parts of the person-thing binary. Rights, even social rights, are inherently individuating. They attach to a circumscribed and bounded entity positioned against a potential violator who also must be circumscribed and bounded, that is, suable. Of course, certain species, rivers, forests, or wetlands may benefit from individual protection, and it's also possible to identify at times specific polluters, developers, timber companies, or even state policies that threaten these things. But this individuation elides the fact that non-human life and its conventional endangerment is part of an interconnected web defying individuation or circumscription. It's not an overstatement to say that the deep methodological individualism of liberal legalism is wholly unsuited to conceiving or protecting nature. This is the point of the earth scientists Lovelock and Margulis's theory of the earth on the model of Gaia, which Bruno Latour, Isabelle Stenger, Pierre Charbonnet, and many others have seized upon as a very productive disruption of the troubling modernist categories we are struggling with here. Gaia is often misunderstood as ascribing a unified holism to the earth or figuring it metaphysically as an integrated living creature or goddess, both misunderstandings are near opposites to what Lovelock and Margulis theorized, and which is now broadly accepted in earth science, namely the presence of what they called, quote, historicity and agency in all life forms on the planet, and the respective effort of each life form to create conditions for lasting in time and expanding in space. Far from ascribing unity or holism or totality to the planet, Lovelock and Margulis theorized the interdependency of earthly life at the site of these efforts to persist in time and expand in space, and located Gaia's multiple histories and agitations in the complex ongoing interactions among these efforts. That's why, as Latour says, Gaia is not an organism, and there's one Gaia, but Gaia is not one. It's not unified, not metaphysically organized, not godlike. The theory of Gaia undoes discursive conventions of nature for non-humans and for human relations with the non-human. It disputes the idea of nature as either what humans are, reactionary naturalism, or what humans are not, reactionary culturalism, as nature as either what we're reducible to or what is radically other to us. It disrupts what we have come to now call anthropectomy, nature as our opposite. Gaia disrupts the modernist subject-object, person-thing, culture-nature framing, and warns us against imposing a bounded and subjective figure of the rights-bearing individual on a fantasy called nature. Neither nature nor any of its parts are, as several have argued, an it or a she, but a vast and complex they, incessantly intersected by our own theyness. Moreover, the most significant anthropogenic effects on what we call nature, climate change, plunging biodiversity, species extinction chains, these are also wholly ineligible for individuation. They comprise complex webs of finance, production, shipping, consumption, waste, and disposal that rights discourse cannot capture or remediate. Threats to particular species or zones, let alone to a habitable Earth climate, to biodiversity or water tables, are rarely created by a single tangible adversary. Thus, the individuation of both subject and adversary carved by rights claims moves against both what nature is and how it works and what it requires and what threatens it the most. It also comports poorly with consciousness of how to live with nature differently, to become a different demos, my concern in the Reparative Democracy Project. Rights adversarialism, of course, also necessitates representation. Nature cannot speak for itself in court, and the problem of multiple and contesting representatives is ongoing in the rights for nature litigation. The representatives and agencies involved are contingent and malleable. As Gwynne and Livermore have argued, multiple litigants pursuing conflicting goals come to court claiming to speak on behalf of nature's rights, forcing courts not only to balance heterogeneous effects of policy choices, but also to arbitrate between alternative, plausible representational claims, which courts are almost universally ill-equipped to do. Placing nature under the rubric of rights also sets these rights against those of property, consumers, industries, developers, unions, financiers, and other powers, where nature is always as likely to lose as win. It often sets nature against itself. A hydroelectric dam or solar farm may be terrific for reducing fossil fuel use, but disastrous for a habitat or certain species on it. Nature is also replete with parasitic and symbiotic relations that develop partisans on both sides, not so different from the fetus-woman opposition in contemporary abortion debates. Neither unified nor harmonious, nature features contradictory needs, enmities, internal threats, and violence, all of which are stressed and intensified by the imbalances introduced by the Anthropocene. How to protect such a domain, which scientists struggle to find proper approaches to, with a tool as crude as a right. Then there's this. Notwithstanding the purest end of the liberal legal imaginary, we know that rights are not insulated from politics in their creation, interpretation, or redeployment. They're bendable and mutable, transformed, even reversed by political discourse and jurisprudence, as my country has made so clear in recent adjudication of rights. Rights to free speech, extended to corporate financing of elections, rights to conscience, extended to corporations so they can discriminate against LGBTQ people, and rights to control over one's body, which have now been extended again for purposes of discrimination. The point, a simple one, you all know it. The meaning of the right is not in the thing. Finally, there's the relationship of rights to capital. We need not return to Locke for the truism that property rights are the rights of European modernity. From Marx, we know that rights amplify the power of the powerful. From Katharina Pister, that expensive legal teams of powerful asset holders code their assets into law. And from the rapid conversion of nature into an asset class, that capital need not violate the rights of nature to exploit, extract, or deplete it any more than it need violate human rights to exploit, extract, or deplete humans in a capitalist mode of production and finance. As important, American jurisprudence during 4 decades of neoliberalism added more rights to capital than to any other entity, abetting, not weakening, its political, social, and economic power. Even the greatest enthusiasts of rights of nature recognize this problem. Here's David Boyd from his work, The Rights of Nature. It should be obvious that nature's rights cannot be reconciled with endless economic growth, consumerism, unconstrained globalization, or laissez-faire capitalism. We cannot continue to prioritize property rights and corporate rights, burn fossil fuels at current rates, or perpetuate today's linear economy that treats nature as a commodity rather than a community. In sum, whatever the virtues of rights, and they are many, they are too individual, interest-bearing, and uninsulated against capital. That is too humanist and too liberal for the work of protecting nature, let alone incorporating it into the heart of democracy, let alone transforming the demos into reparative democrats. So, what are other ways of bringing nature in? There are many, but I want to just turn to one before wrapping up. In his 1991 work, We Have Never Been Modern, Bruno Latour brilliantly revealed the recursive failures of modernist nature culture, nature human, and nature politics binaries, arguing that there is nothing but hybrids, fusions, interactions. In the same work, he demolished the idea of unmediated representations of humans and non-humans, revealing that mediation through translation, interpretation, and projection is always at work in representing ourselves and our others. What some saw as a loss of order and truth in this deconstructive work was for Latour a horizon of hope. At the book's conclusion, he proposed what he called a parliament of things, as a way of staging the imbrication of nature and humans in political life. He insisted that this parliament could bring the challenges of living together on Earth into a single space of deliberation and decision, where the idea of direct representations and naked truths would be abandoned for an appreciation of the mediation engaged in by scientists, economists, politicians, and interest groups. Latour's idea was that scientists would be nature's interpreters and representatives, just as others are interpreters and representatives of the needs of industries or workers or consumers or cities or regions. Against the notion that this was unrealistic, he insisted that all this entailed, and I'm quoting him, is rejoining the two halves of the symbol broken by Hobbes and Boyle. Quote, half of our politics is constructed in science and technology. The other half of nature is constructed in societies. All we needed to do, he said, is get the representatives all in one parliament, and then, quote, the political task can begin. This was, he adds, no less daunting when they invented rights to give up to citizens or the integration of workers into the fabric of our societies. It's up to us to change our ways of changing. Now, of course, there was plenty of naivete in Latour's liberal democratic vision for building political ecology in the 90s. Above all, it's oblivion to concentrated powers in liberal democratic politics and the fantasy that capital, wage earners, and consumers would just roll over for nature through parliamentary deliberations if the scientists adequately represented nature's needs. These critiques, like those of Rights for Nature, have been rehearsed at length. But more important for our purposes is that Latour himself repudiated the Parliament of Things 30 years later. In his words, a chasm opened between the early 90s and the present. I was much too optimistic in the 90s, he said. I was imagining a republic, a democracy, just extended. It was based on the idea you could have a common world where people would disagree but come to an agreement. Politics of nature implied there was a possibility of a general agreement on the procedures. That is not the case now. We live on different planets. You can't agree to disagree if you are not on the same planet. He's referring to the right and the left. Now, he says, we have entered a condition of war over a planetary future and who will and will not be a part of it. Latour could not have imagined the rapid escalation of this war to its current pitch, accelerating even in the mere 3 years since his death. The assault on the planet today is matched by the assault on the parliamentary democracy Latour hoped would protect it, and by the assault on the science he counted on to represent it. One scene in this war brings us back to the rise of supervenient power politics in the US, where regulations that took decades to build have been shredded in days. In the Trump regime's attack on the Environmental Protection Agency, the most significant target is a tiny one. It is a 2009 endangerment finding that links 6 greenhouse gases to climate change. It's just a finding of fact. This finding of fact was filed in 1999, deliberated about for 8 years, finally upheld by a 2007 Supreme Court decision, confirming that gases are pollutants covered by the 1970 Clean Air Act, and that therefore the Environmental Protection Agency administrator could regulate and enforce them. In 2009, the finding was finally signed, 10 years after it was filed. And in 2010, its publication authorized imposing federal limits on emissions. Since that time, the finding, of course, has been regularly challenged by industry, especially but not only oil and auto. The challenges range from too much uncertainty exists about climate change to multiple claims of harm to industry. All the challenges to date have been reviewed and rejected. But the Trump-Musk regime doesn't waste energy on challenges and appeals. Following the Project 2025 playbook, the EPA administrator, oil baron Lee Zeldin, targeted the finding for reconsideration, which is a project of unwinding that could take decades, but the agency is now proceeding as if it had been set aside. 3 weeks ago, Zeldin announced the rollback of 31 environmental rules pertaining to air, water, and climate change, jettisoning decades-old regulations on power plants, oil and gas production, greenhouse gas reporting, wastewater regulations, risk management of chemical production and refineries, air quality standards, and of course, everything to do with environmental justice. At the same time, Musk's DOGE gutted the EPA's workforce. 1,500 personnel have been fired to date. The entire scientific research arm has been closed, and the agency's funding has been slashed by 2/3. The strategy is the basic one of the Trumpian revolution. Dictate, overturn the finding through executive order. Disable through defunding, destaffing, and deregulating. Delay, let the courts take forever to sort it out while drilling restarts emission standards are kicked aside, and capital is released from almost all environmental oversight. Chaos. Make it impossible for any remains of the agency to do its work. There is also privatization, but that's a story for another day. The EPA website declared, these announcements represent the greatest and most consequential day of deregulation in the history of the US. The overhaul of the endangerment finding, along with other massive rules, everything's massive under Trump, represents the death of the Green New Scam and drives a dagger straight into the heart of the climate change religion that has been at the top of the EPA website for several weeks. So, war. What can my little fledgling reparative democracy do in this war, aside from whimper in a corner? Especially given our not-so-secret hunches that it's easier to destroy than build, that it's easier to wield power for purpose with autocracy than democracy, hence Leninism, that capital always wins, and that once nihilism, with its devaluation of truth, fact, science, the social contract, care for the future, and morality, once nihilism takes hold, nothing can be protected from it. Power is all. But consider this. Trumpism rests in openly remaking the state for the accumulation of capital, imperial power, and patriarchal ethno-nationalist culture. This is not a very sticky, popular, long-term vision, even if it has thus far been brilliantly crafted to anoint resentments and offer the many a delusional identification with supremacy and power. Our task is to craft a popular vision that offers the many a substantive part in political equality and power in the making of a habitable future. This is the work of reparative democracy. That said, Trumpism reminds us that seizing the state remains key to such revolutionary transformations. That is what is happening right now in the US. Can we simultaneously build reparative democratic experiments and challenges on the ground and strategize to wield state power for reparative democratic ends in the near future? Can we build a potent left statism in conjunction with decentralized reparative democratic subjects and projects? Can we enter political life finally with equal commitments to democracy and power? Can reparative democracy meet this challenge? Thanks.